Hello, reporter room investigators. Let me make sure I have my mic on. I do. Come on in. Come on in. It's great to have you here on a Tuesday afternoon. Today, we're going to be talking about the Bryan Kohberger case. So, what's going on with that August 21st traffic stop, that mystery traffic stop? We're going to talk about that. We're going to talk about what the prosecution is actually trying to prove and they got the traffic stop in. You'll recall that the Latah County judge, Judge John Judge, kept the traffic stop out, but this judge, he allowed it to come in, but he's bringing it in under different circumstances. We're going to briefly touch on BK's autism diagnosis. We're going to talk about his alibi. Will Ray take the stand? Will Bryan Kohberger take the stand in this? And four huge things that could sway the jury, and one new clue. My name is Jessica Davies. I'm an investigative journalist, and my job is to investigate crimes, crime scenes, and potential suspects, and share with you how to do the same thing. If you have not subscribed to Reporter Room, please do. It's free, and it helps me out a lot. Like, share, leave a comment, and know that everything I'm sharing with you is my opinion. Bryan Kohberger is innocent until proven guilty. And I do want to say thank you to our subscribers, our mods. And our mods are the ones with the wrenches, and our subscribers are the ones with the red, green, and blue verified check mark. So come on in. Tell me where you are from. All right, let's.
Their whole case here, they just have to make up probable cause. They went through a very lengthy analysis of the cell phone. What people have to understand is the cell phone is not like GPS. That the scientist and the science behind this, when they do match his DNA with the DNA that was found at the crime scene, I think that will be an extremely important event. 51% that there was a crime.
This is Reporter Room with Jessica Davies.
Okay, so thank you for joining me today. I just wanted to do a proper intro. We haven't done one for a while. Okay, so let's go ahead. You guys know I love to get started. Come on in, tell me where you're from, and let's dig into this. So let's start off with what the judge ruled on Friday, that BK's lawyers cannot mention his autism diagnosis to the jury unless Bryan Kohberger takes the stand in his own defense. Is this judge tougher than the Latah County judge? You know, Ann Taylor made the choice to move the trial from Latah County to Ada County. And it seems like the Latah County judge, Judge John Judge, was a little bit more sympathetic to the defense. This particular judge, I believe, in Ada County is very fair, very balanced. And he's also no nonsense. I don't think he's sympathetic to either prosecution or the defense. He pushes back hard on both. So BK's lawyer said, so the judge said that mentioning BK's autism diagnosis, his attorneys and Taylor thought that he would be perceived as odd or weird. She didn't say weird, that's me, but odd, as he sits at the defense table. But the judge absolutely disagreed, stating that BK's demeanor wasn't relevant. So let's we're going to talk about BK's mystery traffic stop. We don't know anything about this August 21st traffic stop. Well, we're going to when we're done with this live stream. So what is the prosecution actually trying to prove with this? And did the fact that the prosecution got another bite at the apple? You'll recall that the Latah County judge said no to allowing this video of BK at this August traffic stop in 2022. Now, what the prosecution did was they came in with another reason of why they wanted to present it. And they said that they just wanted to present it to prove that it was BK's car. The defense was adamantly opposed to this. And this judge said, yes, it is coming in. So let's find out more about this traffic stop. And then we're going to do a deep dive into BK's alibi options. Will Ray still be taking the stand in this trial or not? Will Bryan Kohberger have to take the stand to establish his alibi? 4 huge things that could sway the jury and 1 new clue. All right, so let's go to the motion on this. Let me take this down. Thank you so much for joining me. Come on in and tell me where you're from. And I just want to make sure I'm at the... I have so many packages. I have 1, 2, 3, 4, 5 packages open besides this one. Okay, let me grab this one. This is perfect. Okay. So we want the orders. All right, so we're going to start a little bit with the judge's orders on this, and you can see he addressed the psychopath, sociopath. We already talked about that. Improper DP comments. We already went through that. Unnoticed evidence. He's put that off. So we're the IGG. We already know that both sides agreed not to present that. The alternative perpetrator defense. He said that Ann Taylor can present an alternate perpetrator, but he said that there needs to be some kind of proof tying them to the case, and she needs to provide that to him prior to providing that. So she can't just pick anybody out. So let's go down. So we know about the timing advance records. I explained to you guys on the last live stream what those were exactly and related to BK's cell phone. Now we already have talked about the fact that the state contends it never received these records from AT&T. And the judge did agree with the prosecution on the advanced timing records. So now we're going down to this. Let's look at this traffic stop. So here we are. Okay, so this is the notice to that prior traffic stop. So we don't know a lot. I have been able to dig up some good information for you guys on this traffic stop, because this is not one that we've seen. This is not the body cam footage of him when he pulled into the crosswalk where the female police officer stopped his car on the WSU campus. We've all seen that one. We've seen the traffic stops where he and his dad were stopped twice for tailgating. We have not seen any video of this particular traffic stop. So the state did move to admit it. They specifically wanted to admit, let me make sure we're all looking at the same thing. Okay, we are. This really absolutely wanted to admit that the officer's OVB footage of the traffic stop, as well as citation, arguing the prosecution said it's relevant to proving the defendant's identity, vehicle ownership and control address and phone number. So and now the defense, they did not want this to come in. They point to the Idaho Supreme Court's law that stated that evidence for prior misconduct is relevant on the issue of identity, where evidence demonstrates sufficiently similar as well as distinctive characteristics or patterns between the prior misconduct and charged crime. They cited State versus Porter. Confusingly, defendant argues his prior traffic stop bears no resemblance to the charged crimes and therefore cannot be relevant to the identity. He argues that it's unfairly prejudicial. So ultimately, this is what the judge decided. The judge said the court finds evidence that it is relevant to establish the defendant's identity and link him to the charged crimes. And I'm going to show you why I think this is relevant, why the judge decided this way. And the prosecution, the Latah County judge, was not letting this in. So the prosecution was able to use the fact that they had a new judge to come in and argue this, to have this admitted, but for a different reason. Indeed, the citation and OVP footage up to the point that the defendant provides his phone number served to identify the defendant by name, physical appearance, phone number, and address. The evidence also establishes the defendant as the registered owner and driver of a vehicle, the make and model, which was thought to be used by the iller. Further, the person who committed the crimes. Further, the evidence places the defendant in Moscow the night of one of the dates of interest. So I think this is going to line up with cell phone pings, you guys. alleged by the state to be relevant to planning the charged crime. All of the factors played a role in the investigation of the crime. While the defendant cites to case law discussing the identity IRE 404B as requiring strong similarities between the bad act and the charged crime, this is in the context of, this is the judge saying this, establishing identity through signature quality or modus operandi. And so he cites Porter and says, discussing how evidence of modus operandi can prove the identity of the defendant as the perpetrator of the crime. The state, however, is not seeking to introduce the prior traffic stop to establish a modus operandi. Therefore, the defendant's case law and argument is not well placed. So that traffic stop is coming in. So let's talk about why this is so relevant. So let's look here. We're going to do a little bit of map time. Okay, so the traffic stop occurred at Farm Road and West Pullman Road. And you can see, I have up on the screen, you'll see the red thing. You can see where this is in relation to the 1122 King Road house. And this is what the prosecution was trying to get in, and the Latah County judge. So I do want to get your opinion. Do you think that this Latah County judge, did Ann Taylor make a mistake switching to a different county? Yes, she might get a more liberal jury, maybe, but I don't think I think the Latah County judge was more defense sympathetic, whereas this judge appears to be just by, it's by the law. It's by Idaho law, period. So then you can look and see where BK lived. He lived in Pullman, and you can see he was traveling to Farm Road and West Pullman Road. So this is that mystery traffic stop that we don't have any of the body cam footage yet on this. So now let's go to the third slide. Then you can see Pullman. And then you can see how easy it is, how close it is. It's 6 minutes from the 1122 King Road home. So was he pulled over on the way? Is this what the prosecution is going to try to say? Look at that. There's Pullman. You can see Pullman is above the street view picture. And you can see Kitzmiller, Pullman, and Whitlow are all over here on your screen. And then you can just see where he, took that route, and he got pulled over just 6 minutes from the 1122 King Road home. So really, really close by. And I think they're going to line this up with phone pings to help establish that the phone pings do link back to Bryan Kohberger's phone, in my opinion. Let me know what you think. All right, so more on this. So we're going to talk about the alibi in just a second. So please stay with me. Let me highlight this so I know I'm coming back to it. Okay, so we're going to talk about the alibi. We're going to talk about whether or not Cyree is going to take the stand. Will Bryan Kohberger take the stand? 4 big things can sway the jury. And so let's talk about this traffic stop. And let me just leave the map up in case anybody joins us late. So they're like, what is she talking about? This is the traffic stop. It's literally 6 minutes from the house. And I believe that law enforcement is going to line up this traffic stop with cell phone pings, and they're going to, or that it lines up with cell phone pings that they already have. And that they're going to prove to the jury that it is his car and it is him pinging off the cell phone tower. So BK was stopped, just to clarify, by the Latah County Sheriff's Deputy, CPL Juke, and the 8548 phone number, that's BK's, one of his phones, he had, the other one was from Pullman, Washington, was utilizing cellular resources consistent with the location of the traffic stop during this time, which again is Farm Road and Pullman Highway. If you look at the screen, I have it pulled up for you. So the whole point of this traffic stop is to show how law enforcement, one, got BK's phone number, And two, that their cell phone ping technology is reliable. This is what I believe they're going to work to establish. So they probably, they may not have him on camera for those 12 cell phone pings leading up to the crime. We know that they have the Hyundai Elantra on camera on the night of the crimes, November 13th, going to and leaving from the crime scene. But are they going to be able to use this traffic stop to prove that if the cell phone pings place him there and he was there and it's going to be let in, is that going to be enough to establish to the jury that the cell phone ping technology is reliable? Or will Ray be able to take the stand and overcome this information? So the cell phone number was later used by detectives during their investigation of doing away with Kaylee, Maddie, Ethan, and Xana at the 1122 King Road home. Law enforcement was able to track BK's cell phone history, namely connection to the cell towers. Now, those records, according to the affidavit, show that the phone near the crime scene in the months leading up to November 13th of 2022. And we know the cell phone pinged just after 9 a.m. after Ethan, Kaylee, Maddie, and Xana were all done away with, just after 9 a.m. on the morning of the crimes. Now, the Butler Township Police Chief Fessner, who spoke to Eyewitness News, said that the routine traffic stops oftentimes can provide information to help solve crimes. He said, quote, the police officer is using his prior experience and comparing it with any abnormalities that he's seen before. He's constantly assessing if there's something abnormal from the stops he's done before and if anything stands out. Now, according to the investigators, the movement of Bryan Kohberger's cell phone matched the movement of his Hyundai Elantra near the crime scene. On November 29th, a police search of the vehicles registered to WSU students revealed a 2015 white Hyundai Elantra registered to Bryan Kohberger, originally with Pennsylvania plates, but just 5 days after the crime, they were changed to Washington plates. And we're going to talk about BK's alibi. Will Ray take the stand? Will Bryan Kohberger take the stand? 4 huge things that could sway the jury, and a new clue in just a moment. But let's continue on with the cell phone, because I think this is going to be really, really critical. And I think this mystery traffic stop, which the Latah County judge wasn't going to allow the jury to see, this judge in Ada County is allowing it. Do you think that Ann Taylor has made a big mistake by moving the trial to Ada County? What do you guys think? Okay, so law enforcement tracked BK's cell phone, and after identifying him as a possible suspect, the police discovered that he had been subject to this August traffic stop. And at the time, he gave Moscow PD his phone number. So in late December, the investigators began working through cell phone records. So remember, he was identified on December 19th as a suspect. They began working through the cell phone records, attempting to uncover whether his cell phone had pinged cell phone towers near the crime scene, going to the 1122 King Road house or coming from. So if we go back to page 11 of this affidavit, we're going to look at how they identified Bryan Kohberger and how they talked about this traffic stop. And then we're going to dig into Bryan Kohberger's alibi, and we're going to talk about Ray and will he take the stand. So let me put this back up and take this down. Okay, so I am going to page 12. Let me back this up. So I'm on. Okay. So this is the hold on one second. Yeah, this is right. Okay, so we're going to talk about this alibi. All right, so the state moved to preclude Bryan Kohberger from offering any evidence in support of an alibi other than from Bryan Kohberger himself. So the state wanted Bryan Kohberger to take the stand. Now, the basis for the state's motion is the defendant's failure to comply with the notice requirements governing alibi evidence. Let me make this a little bit bigger for you guys. Make sure I'm not blocking it. Nope. Okay, we're good. All right. So the basis for the state's motion is the defendant's failure to comply with the notice requirements governing alibi evidence. So you will recall that pursuant to IC 19-519, if requested by the state during discovery, and they did request it, a defendant intending to offer an alibi must file a notice listing the specific place or places. This is Idaho, what the Idaho statute says. The specific place or places where the defendant claims to have been at the time of the alleged offense. The names and addresses of the witnesses upon who he intends to rely on to establish such an alibi. The court has the discretion to exclude testimony of any undisclosed witnesses offered as to the defendant's absence from the scene in the offense. So are they going to allow Cy Ray to take the stand? I don't think he's going to be able, I think he'll be able to take the stand, but I don't think he's going to be able to provide the partial alibi that Ann Taylor was planning for him to provide. And let me share with you why I believe this. This is still the prosecution. Remember, just because the prosecution says it doesn't mean it's true. Just because the defense says it doesn't mean it's true. Ultimately it's what the judge decides, and he, does have an opinion on this. So the alibi is defense based on physical impossibility of the defendant's guilt by placing the defendant in a location other than the scene of the crime at the relevant time. Black's Law Dictionary. Hence, in setting forth the notice requirements for a alibi defense, and he cites the 19-519 and ICR 12.1, require a defendant to proffer evidence establishing where the defendant was at the time of the alleged offense. And this makes sense because what you don't want to do is seat a jury, go through all the expense of getting ready for a trial, and then have the defendant say, well, I was at the 7-Eleven with my friend Jimmy, and Jimmy's going to take the stand and testify. So this is why it's important for the defense to say it. And now the Latah County judge did offer the defendant, Bryan Kohberger, extensions on that 10-day, because the state, requested this information right away, and Ann Taylor successfully got multiple extensions. So the evidence, let's continue on together. Evidence only counts as alibi evidence if it proves the defendant could not have been present at the scene of the crime at the time it was committed. And they cite case law here. If any alibi fails to account for a defendant's whereabouts for at least some period of time during when the crime was reasonably committed, it is not an alibi. And they cited multiple case law. And it's put here, the defendant was not entitled to an alibi instruction when his witness did not account for his whereabouts at the time of the offense. So what is, what they pointed out was that BK at this time had only provided notice that he was out driving in the early morning hours of November 13th of 2022 throughout the south of Pullman, Washington, and west of Moscow, Idaho. He intends to present testimony by his expert, Cy Ray, to partially corroborate. Now, the reason they have partially corroborate here in quotations is because this is how Ann Taylor herself, the defense attorney, described it. So Cy Ray to partially corroborate his alibi using CSLI data from the defendant's cell phone. However, the alleged offense occurred between approximately 4:07 a.m. and 4:20 a.m. At most, Mr. Ray, this is the prosecution saying this, can opine as to where defendant's cell phone was up until 2:54 a.m. when it was apparently turned off, and approximately 4:48 a.m. when it began reporting to a network. The defendant has provided no evidence as to his location at the time of the crime. In other words, he has provided no alibi evidence as contemplated by the rules. So this is what the judge said. The judge said the court will not categorically preclude the defendant at this point from offering an alibi at trial. He cited State versus Juarez, and said whether to exclude late disclosed alibi evidence requires weighing prejudice to the state against the defendant's right to a fair trial and considering whether less severe remedies are sufficient. There are still 4 months until the trial begins. If the defendant does not unearth alibi evidence, it is his obligation to immediately make the state and court aware of it. At that point, the court can apply Juarez standard. Excluding at this time is premature, and therefore the motion is denied, subject to being re-raised if the defendant does not disclose alibi evidence. However, at this point, the defendant has not provided an alibi, partial or otherwise. So what the judge is saying here is that Bryan Kohberger, he's not accepting this partial alibi of where Bryan Kohberger was. So he's saying point blank, Bryan Kohberger has not provided an alibi. However, if he would like to, we have 4 months until the trial. If he would like to, provide an alibi, that's fine. I'll give him a little bit more time to do that. So that's just me paraphrasing basically what the judge said. So come on in, tell me where you are from, and let's see where we are now. Okay. So will Cy Ray take the stand? I think he still will take the stand, but I don't think the judge is going to allow him to give a partial alibi for Bryan Kohberger. If Bryan Kohberger can produce an actual alibi for where he was during the time of the crimes, that's fine. Or Bryan Kohberger will be allowed to take the stand to provide himself an alibi. Now, will Ann Taylor let him take the stand? I doubt it. I doubt it. And this just goes back to the, autism diagnosis that she's, claiming that he has autism. And now the judge is saying that Ann Taylor can't raise that anyway, because he said he doesn't think, one, that Bryan Kohberger's demeanor while he's sitting there is relevant. Two, he thinks it's going to draw more attention to anything Bryan Kohberger might say or do in a negative way. So at most, I think, Cy Ray can opine as to where the defendant's cell phone was up until 2:54 a.m. when it was apparently turned off at 4:48 a.m. So this is, what the state is saying, what the prosecution is saying. So the judge basically denied it, saying that it's premature. But he also said that he wasn't accepting the alibi, this partial alibi. He's not accepting that either. So the defendant has to produce an alibi. So this is very, very interesting. So now we have the traffic stop with another link of Bryan Kohberger with his cell phone pings, which I think is going to be, another piece. And remember, this is going to be a circumstantial case. Nobody saw him actually committing the crime. Well, if they did, they're not here anymore, and he is innocent until proven guilty. But this is not a court. I am not a judge. You are not a judge. So we're talking about this case. So let's go through. Let me pull up what the judge said.
Or not. And certainly the rules on self-authentication are crystal clear as to what is allowed. And so if it meets those, then I imagine we won't have a problem. I add anything, counsel?
No, Your Honor, I won't right now.
All right, let's talk about alibis. This is the state's motion in limine.
Okay, so we're going to look at where he really pushed back on the prosecution, on the defense. He really pushed back on this case. Let me say hello to chat. Thank you so much for being with me today. Let me see. Come on in. Tell me where you're from. Come on up and talk to me, you guys. I want to hear what you guys have to say. Let me back up the chat a little bit. I am behind. All right. see where we are. I wish the scroll button would just let me go to the beginning. It does not. Okay, I just have to keep trying to slide it up. Let's see where we're at. I think we're to the beginning now. Okay, Leslie's here. Thank you for modding today. Hi, and Jazz. So come on in. Tell me what you guys think about this alibi. I'm really curious. Thank you to our head mods and Jazz. Welcome, Donna. I'm glad you're here. Welcome, Barbara. Thank you for joining me today. Pepper is modding today. Thank you so much for modding today. Pepper. Mike is our other head mod today. Thank you so much for modding today, Mike. Kristen's here from Facebook. Welcome. I've seen you in our Facebook group chat. If you haven't subscribed, please do. And please give this a thumbs up. Veronica said, hi, Jessica Mods. I'll be watching you from my TV. Thank you, Veronica. And thanks for helping me get this out by putting this video, this live stream into chat rooms today. Really appreciate you. Hey, Dee Dee. You're ready for Lori Daybell's verdict? Well, okay. Christine's here. Kathleen is here. Beth is here. This is our other head mod, Brother Mike. Christy is here. Christy, when we do the next live, remind me, I'll give you a wrench today. Daphne is here. Toss Penny is here. All right, so come on in. Tell me where you're from. Northern California. The islands. Wow. All over the place. Number 37, after I clicked it, it jumped to 48. Well, thank you for the thumbs up, Kirsten. Hi, Maria. Welcome from California. Yeah, please help in the chat. Blue Sunshine is here. Born in Michigan. Yeah, so this whole thing is very, very interesting. Hi, Juanita. He does not have autism. A lot of people feel the same way that you do, Juanita, about the autism diagnosis. And you know, the reason that they're having a lot of questions is that I think that, and I do think it, you know, you guys have a fair point with the autism diagnosis, because I think that if Ann Taylor really had, I know she has a diagnosis from Dr. Orr, so I'm not saying she doesn't have a diagnosis, but I think if she had like the information that led to that diagnosis, wouldn't she have been putting that out publicly? Wouldn't she have been attaching that and crowing from the highest rooftop that her client should avoid the capital punishment because he has autism? I'm, you know, curious what you guys think. Hey, Letty. Kirsten also doesn't. If you think he does have autism, put a 1 in the chat. If you think he does not have autism, put a 2 in the chat. Okay. So yes equals 1 and no equals 2. Thank you, Enjas, for gifting a reporter room membership. Wow, if you got that, please let me know who you are. And thank you, Brother Mike, for the $1.99 super stickers. I did take your super stickers that I got last time, and I'm about to throw these out. But these are my headphones. They broke, literally just snapped. And so I was able to get new headphones, and I'm wearing them. So thank you so much for that, you guys. And thank you, and Jazz, for gifting another reporter room membership. That is so nice of you, and so nice of you also, Brother Mike. So Christine likes the new headphones. Well, thank you so much. A big thank you to you guys for helping me be able to get those. Tony, hey, happy Earth Day. That's right, it's Earth Day today. Hi, Pen Jam. Hi, everyone. I miss spending time with you guys, getting over a nasty bout of COVID. Oh, I hope you feel better. Hi, Bob. Everybody drink. Hi, Bob. Okay, and Red Cloud is here, but waiting for the verdict. And Cheryl is here. Toss Penny is here. Mindy is here. All right, so let's keep going. All right, so this has been hotly debated. Let me move myself out of the way. This has been hotly debated. All right. Make sure I'm not blocking anything. Nope. Let me make myself just a tad smaller. All right. So this has been hotly debated. A lot of big feelings around the judge here when he's talking about the alibi. Let's watch it together and see what he said. Put a thumbs up in the chat if you can hear them.
Thank you, Your Honor. Excuse me. First off, I want just for the record to make a record of the corrections to the typos that I missed in our initial filing. I emailed Your Honor's staff attorney and counsel over the weekend. There were dates that were wrong. Page 1, item number 2 of our motion. It should be July 27th instead of July 22nd on that.
And I just want to tell you who people are. This is Bill Thompson. He's talking at the podium. He's the defense. He's the prosecutor. You can see behind him, sitting over here, is Bryan Kohberger and his defense team, Ann Taylor. You can see her, a little bit of her head. This is Ashley Jennings, and these are the other two prosecutors, and then this is the judge in this case. So we're talking about the alibi. They have BK in a light blue suit, light blue shirt, so he's out of his suit, and his seat's also been lowered. You can see now he is almost head to head with the females. They have lowered his chair, in my opinion, as low as they can lower it. We saw that Jose Baez do this in the Casey Anthony trial, and it worked. Wasn't the only thing. They also had her dressed up like a librarian, and we saw them attempt this in the Jodi Arias trial, where they had her also going from the blonde bombshell with, everything up and out and very vivacious to, being very subdued with brown hair, mousy brown hair, and librarian glasses on. So, now they have Bryan Kohberger instead of in the suit. They have him looking younger, in my opinion, with the light blue. I think they're going to put him in a lot of pastels, and then they've lowered his seat so he doesn't look like he's as tall or as big. So maybe he couldn't commit this crime. Remember, one of Ann Taylor's arguments is going to be that he could not have committed this crime because he's not physically capable of doing this. And we saw this being argued successfully in the O.J. Simpson trial as well.
That particular court filing from 2023, we overlooked, and I apologize, the defendant's July 24th, 2022 initial alibi response, which, as the court can see, essentially wasn't a response at all, other than we'll come up with an alibi at some point. And then page 2, item number 7, it should be February 29th instead of February 23rd for the date. And I apologize to the court again for those oversights. And they're certainly entirely my fault.
And I'm wondering how Bill Thompson, who's kind of folksy, he's, a small town, Latah County is not big, Moscow's not big, how this small town prosecutor is going to play against a big city, one of only 2 capital punishment certified attorneys in that area, Ann Taylor, how you think this is going to play to the jury in the city, in Boise, which is a big city.
This issue has been argued back and forth in court since 2023, as the court can tell from the numerous filings that have gone back and forth up in Latah County that brings us to today. The state filed in accordance with the applicable rule and statute 19-519 and court rule 12.1, a discovery request with an alibi demand that requires the defendant to specify the place or places that he claims to have been at the time of the alleged offense, and then identify witnesses who the defendant intends to rely on to establish that alibi. The state's position is that to this date, the defendant has yet to do that. The best that we have is the defendant was out driving around. Well, we knew the defendant was out driving around. We have other evidence that show the defendant was out driving around. His phone was turned off, so we can't trace his exact location at the time of the offenses, but it overlaps and coincides with the time of the murders. The can's been kicked down the road several times on this, and it's nobody's fault. Judge afforded the defendant multiple opportunities to provide a compliant alibi response. That never occurred. The defendant's response from earlier this year doesn't have anything new or different. It talks about partial corroboration of a partial alibi, which frankly, the statute doesn't talk about partial anything, nor can we find that in the case law. The defendant acknowledges that their cell phone expert, Mr. Ray, can't account for the time of the homicides itself. Of course, we know that because the defendant's phone was turned off. So the only person who can testify to an alibi, if there is an alibi, is the defendant himself.
And of course, the prosecution would love for Bryan Kohberger to get on the stand. And in my opinion, unless Dan Taylor comes up with an actual alibi with Bryan Kohberger, that's going to be the only way they're going to be able to establish it. Let me know if you have a different take on this.
If he elects to testify, that's fine. And the state's position is that he's allowed to testify, but under the statute and the rule for alibi notifications, there should be an order from the court prohibiting evidence from any other witnesses as to the defendant's location at the time of these offenses. The defendant retains his right to testify to that if he elects to do that. But nobody else should be asked to testify about specific places where the defendant has been, because we can't respond to that at this point. And to our knowledge, there's nobody else who can say the defendant was at a specific other place.
What about their expert, cell phone expert, who, as I understand it, will testify as to where he was or wasn't?
Okay, so the judge is point blank asking about Ray.
I don't believe that that's what his expert can say. The best their expert can say is that before the defendant's phone was turned off, the defendant's phone was south and potentially west of Pullman. But that was a significant time or a notable time before the homicides themselves occurred here in Moscow. There's nothing in the cell phone data that shows where the defendant was at the time of the homicides.
You don't disagree about the right to put on that evidence?
No, that's fine. I mean, that's an issue, the battle between the cell phone expert on the activity of the defendant's cell phone and what direction it was, but that doesn't apply to the time when the homicides occurred.
Okay, so I just wanted to show you that I do believe that Ray is going to be allowed to testify. I just don't know if he's going to be allowed to testify. He's not going to be allowed to testify for a partial alibi. BK either has to come up with a real alibi or take the stand himself and provide a real alibi.
You're just looking to ensure that there's no witness who's going to appear who says, oh yeah, he was at my house at 4:06.
Yes, sir. Thank you.
Mr. Kohberger has consistently maintained his innocence and said that he was out driving in the early morning hours of November 13th, 2022.
And he can testify to that.
Okay, and he can testify to that. Boom. Okay, so we already had a hint of how the judge was going to rule, and that is how he ruled. So let's continue on, because there's this part of the hearing has been hotly contested in the comment section as to who the judge was directing what comments were, who was told that they were needed to be reminded that they were an officer of the court, who was the judge talking to when he was talking about disbarment. So let's continue on together, shall we?
I'm going to get to that. We provided Mr. Ray as a partial corroboration of Mr. Kohberger's alibi in an abundance of caution. The thing I didn't want was to be here with Mr. Thompson saying they should have told us they had a partial corroboration. Now they can't use it. So that's why we disclosed Mr. Ray as early as we possibly could. Mr. Ray took the stand in a motion hearing last May, I believe, and the state chose not to cross-examine him. I disagree that Mr. Judge gave us repeated opportunities to produce more. There was a mix-up about what an order meant when speedy trial was waived and the trial was reset and all of the deadlines were extended. That was the thing that happened there. So it wasn't repeated times that we had an opportunity to say more.
Well, John Judge, just to be clear, did give the defense way past the 10 days of when the prosecution, that he gave them months to come up with an alibi, and then they only came up with a partial alibi. So I just want to, advocate for John Judge in this.
But I will say this. This has been brought up repeatedly by Mr. Thompson. His pleadings with the court, his briefing, have a lot of reference to Mr. Kohberger having the ability to testify. In the few minutes he spoke just now, I counted 5 times he made reference to that. Our view is that's getting dangerously close to commenting on his right to remain silent. And I would cite
And you don't want that face from this judge. Watch the judge's face while
It doesn't apply to the time when
she says this.
Judge gave us repeated opportunities to produce more. There was a mix-up about what an order meant when speedy trial was waived and the trial was reset and all of the deadlines were extended.
Watch the judge's face.
Was the thing that happened there. So it wasn't repeated times that we had an opportunity to say more. But I will say this. This has been brought up repeatedly by Mr. Thompson. His pleadings with the court, his briefing, have a lot of reference to Mr. Kohberger having the ability to testify. In the few minutes he spoke just now, I counted 5 times he made reference to that. Our view is that's getting dangerously close to commenting on his right to remain silent. And I would cite the court, the closest case we could find.
Judge did not like that. He didn't like that.
Was State versus Haggard. That's at 94 Idaho 249.
I think the issue is who's going to say he was out driving around looking at the stars?
Well, Your Honor, I think that's going to be a trial issue. And I think that if that's commented on trial, that's a comment on his right to remain silent.
The question is whether they can comment on it. The question is whether you have a witness who's going to testify to that he was at a particular place between the hours of 2:57 and whenever his phone came back on in 4, so whatever it was.
4:48.
4:48. If so, you have an obligation to produce that. If not, and your testimony, your presentation is that this is what was going on, you have to have somebody that's going to put that into evidence. You can't testify to that.
I'm certainly not planning to testify to that. I'm responding to requests for alibi. And a lot of times in cases, there is not going to be a response because a person's alone. The court's aware of that. But when you have what I considered a partial corroboration, that had to be put out there so that I could make sure I could call Mr. Ray to the stand.
I don't think they're contesting that, as far as I can tell.
That's what I heard them say today as well. I'm explaining why we put that out there. I would say that the state is continually asking a question that is a problem that hasn't arisen at this time yet. The only fear that I have, because of their repeated questions, is that there is something somewhere in the 68 terabytes of discovery that I haven't come across yet. If that's the case, I'd ask the court, if they know of it, I'd ask the court to order them to tell me about that. I can let the court know I haven't read every document in 68 terabytes. I haven't watched every minute of video in 68 terabytes of discovery. We have answered the question now. We've answered the question before, and this continues to come up. I would point out, though, that Idaho Code 19-513, subsection 3, that says if we learn of an additional witness that was not previously known, we can disclose that and the state can challenge that at a later time. I don't have that person now, but if I continue to review discovery that the state produced to me and I find something, then I'll bring it up. But I don't have that now. What I have is partial corroboration, and that's what I intend to produce. I also intend to cross-examine the state's expert about that if he's allowed to testify.
Your Honor, the notion of partial corroboration of the alibi is concerning because that kind of begs the question between complying with the alibi disclosure statute or not. And
Well,
it's that,
why shouldn't we just look at this in terms of the defendant's version is that Mr. Ray, in his expert work, is going to testify the defendant was at a certain place at a certain time, which is up to 2:50, whatever it was. As of this point, they have provided no other alibi witness,
yes, sir.
or the alibi instruction likely is not going to be given.
Yes, sir.
If they come across evidence that supports an alibi, it's their obligation to immediately make you and the court aware of it. And then we'll deal with the issue of whether it is the timeliness of it and how we deal with it.
Thank you, Your Honor. The court articulated it much better than I could. That's exactly what we were looking for. Thank you.
Right.
We're just going to speed this up a little.
All right, let's talk about
Oh,
the
Never mind.
AT&T stuff.
Okay, so this is still related to Cy Ray and the AT&T timing advance records. This is Ashley Jennings, who's on the prosecution team.
Thank you, Judge. This should be fairly simple. The state seeking an order prohibiting the defense from continuing to allege that the state received timing advance records from AT&T for Mr. Kohberger's
When you
phone.
say continuing to allege, I'm assuming you mean in front of a jury.
Yes, what we don't want, throughout the entirety of this case, they've alleged that. We're seeking to prohibit them from making that same allegation in front of a jury because it's false. Timing advance records, really timing is what's at issue. And in 2022, the days that we're concerned about are 7 days. The event that we wanted records for was obviously November 13th. So in 2022, we had 7 days from November 13th to get AT&T timing advance records for anyone's phone. We did do search warrants for other people's phones. We did a tower dump and we did a search warrant for 3 individuals. Those were all done on November 16th within that 7-day period. So the state did receive some timing advance records. However, by the time that Mr. Kohberger was identified in December 19th, and by the time we applied for a search warrant for his AT&T records, we were outside of that 7-day window. So there were no timing advance records to be received, and we did not receive any. The state has submitted an affidavit from Stephen Gordon, the AT&T Director of Compliance, essentially stating that we sought timing advance records, but they were not included because more than 7 days elapsed since November 13th, 2022, and the date of the search warrant, December 23rd, 2022. And the state just submits these affidavits should be dispositive of this issue.
Defense filed a document yesterday, and I don't have all the attachments, but it talks about a timing advance that was produced by AT&T in last April, I think.
Yes, so for that, it's still in reference to these search warrants that were initially asked for in November 16th of 2022. We did a part 1, and then later we did a part 2. But because we put in that request within the first 3 days, obviously a preservation request was also put in. So those records were obtained. So again, we're
So
talking,
you're indicating that there were records obtained as part of your prior notification of need for AT&T to preserve those records.
So the prosecution got the records in 2023 and did turn them over to Ann Taylor and the defense team.
I have nothing further. Thank you.
Your Honor, we're requesting the court deny the state's motion and allow us to cross-examine their expert, Nicholas Balance, with regard to timing advance
What
records.
evidence do you have that timing advance records existed that the state could have acquired for Mr. Kohberger?
Well, Your Honor, specific,
I've read your affidavit of Mr. Ray, and he seems to entirely ignore the 7-day issue.
Okay, so that's the judge. I've read your affidavit from Cy Ray, and Cy Ray, seems to entirely ignore the issue.
Doesn't address it.
Doesn't address it.
Your Honor, his affidavit, I think, starts before to explain to the court some of the history about where the timing advance records come from. When Mr. Kohberger was identified, I'm going to jump ahead and tell you why I think I should get to ask Nick Balance about these records. When Mr. Kohberger came to the attention of the state and they began doing search warrants for Mr. Kohberger's records, on December 23rd, there were 2 separate search warrants for Mr. Kohberger's AT&T records, and they requested timing advance records. And one of the pages that we gave you was the carrier request that said, give us 7 days worth of timing advance records. There were 7 days back, at least 7 days back at that time. Those have never been produced to us. What I've learned in working with Mr. Ray is that obtaining timing advance records now goes through a different process than it went before. FBI agents had a means.
So she admits that it's different now than it was back in 2022.
To get these timing advance records before they were generally available to all of law enforcement. Generally available now comes through the GLDC program, and that happened in 2023.
But he's not indicated he has any evidence that, at least for this time of the murder, that those would still be in existence.
We've never heard from Nick Balance, who is FBI and who has the back door.
From AT&T.
And he's right. The judge has a sworn affidavit from AT&T that they had the 7-day window back in 2022, and that they provided what they could within that 7-day window. And now, obviously, BK wasn't identified. The crimes took place on November 13th of 2022. BK wasn't identified until November 19th of 2022. So not just 7 days, but weeks. Almost 5 weeks later, till they identified BK as a suspect. So well outside the 7-day window. So let's continue on and look at the judge's face. You do not want that face from this judge.
You've heard from AT&T that GLDC did not produce these records in 2022. You've absolutely heard that from AT&T. What you haven't heard is the other way. That's
the other way. I haven't heard that either. I've heard a general description, and I've heard in the affidavit that he received some once and they said, oh no, don't use those. I don't know if those were acquired within the 7 days. He doesn't address the 7 days. And that's a glaring, particularly given the inflammatory language in that accusations in that affidavit, it's a glaring omission.
So he's talking about Cy Ray here.
Your Honor, we don't even have the 7 days worth, which is what the carrier request says. That
the 7 days that he's back home.
Maybe.
I'll ask the state about those. If they receive those. I'm not sure their search warrant covered that time frame, but.
Your Honor, I would say that it did, and I would say their first search warrant was just a 48-hour period. It asked for timing advance records. But then the second warrant,
you would agree there's no evidence that AT&T provided those, or that those were still available by the time that Mr. Kohberger was identified.
Your Honor,
An officer of the court.
He has to remind her that she's an officer of the court. He has to remind her of this.
an officer of the court, I would like to ask Nick Balance that. And here's why. Here's why. The things that I've learned is that the
She refuses to answer a straightforward yes or no question.
7 days is on paper. Sometimes they go back further than other days.
What's the evidence of that, counsel?
The evidence has been in the practice that I've learned from people that I've worked
You're giving
with.
me that testimony now?
I'm not giving you testimony. I'm answering the court's question.
Okay. But you've made some serious accusations against the state of hiding evidence. And yet you've provided no factual basis, zero, that that evidence existed for them to be able to obtain it in December.
Your Honor, in April of, or I'm sorry, it was probably by the July date that I got it, of 2024, I got records from 2022. In some other time in 2024, I think it was May, I got 3,800 people's timing advance
Because they were
records.
asked within 7 days of the date that they sought it.
And the judge is just pushing back here. Yeah, because that was requested within the 7 days window that AT&T had back in 2022.
It was the tower dump from the night of the murder asked within the 7 days.
I understand that.
Okay. So where is the evidence that Mr. Kohberger's timing advance records from AT&T were available to anybody in December without a prior request that they save those?
Well, I don't know if they made a prior request that they save those.
Well, they wouldn't because they didn't know who he was.
You're correct. They didn't know who he was until I think about December 19th.
Correct.
Their warrant for his full scope of records, the second AT&T warrant, asked for all of the records. I haven't seen any of them. That's, even if they were just the 7 days back, I haven't seen any of
What
them.
you're talking about now is a discovery issue of those 7 days that don't sound like they're particularly relevant to the murder. That's a discovery issue you can take up with the court through a motion to compel, which you have not filed. It's not an evidentiary issue in which you can lay down Mr. Ray's conspiracy theory without.
And there's the judge directly describing Mr. Ray's statement as a conspiracy theory.
Any evidence at trial.
Your Honor, we have litigated this issue quite extensively throughout the course of the case. The timing advance records, once I understood how timing advance works, became very important. We've heard different things now than I've heard at different times in the past about this, particularly about the 7 days. That's newer information to me now. But the carrier request forms tell me I should at least have that. I want the court to know that we have had motions to compel on this very issue. We have had different bits of information.
For the 7 days that are after December, in December.
No, Your Honor, because the 7 days is something that's newer and has been brought to my attention
Our
more
motion to
recently.
compel related to timing advance records for November 13.
Our discovery requests were for all of Mr. Kohberger's timing advance records. Our motions to compel covered all of them too. I have this carrier request now that says 7 days, and I have the affidavit now that says 7 days. Those are not things that I always knew when we were litigating this issue.
Okay.
Those are new bits of information. To me, it is a little bit problematic that there's been things that have changed and there might be records out there. Given what you have now with the affidavit with 7 days, if you imagine you didn't know that and you.
I understand your confusion and concern previously. What I don't understand it is now. In light of the evidence, I don't understand Mr. Ray's accusations without addressing the 7 days that he had that information when he submitted his affidavit.
He is available to testify if the court wishes for him to.
It's his obligation and your obligation to establish that evidence of that the state has this, and you haven't done that. His affidavit is quite extensive, and he seems to ignore that issue.
Your Honor, I believe
Okay, so he said that Cyray ignored the issue, that the state has provided what they were able to obtain within the 7 days, and also that he described it as a conspiracy theory. He also had to remind Ann Taylor that she was an officer of the court. See the face on this judge right now when he's like that. You don't want that face from this judge.
that issue is touched on with his knowledge that these kinds of records existed a long time before.
He said that in a very general way about that without reference to the 7 days. And he supposedly received them from some FBI expert to look at for his company, and then was told not to use them. So I don't know, maybe the FBI got them in a way that they weren't supposed to at that time, for all I know. He didn't name names. He didn't identify it. He didn't put it into any context. The state had indicated and they provided AT&T sworn testimony that they only keep them for 7 days. And yet he makes the accusations that he did in his affidavit without addressing that 7-day issue at all. And so I guess my point is if you want to cross-examine the witnesses about why didn't they rely on the AT&T timing information, you've got to show some factual foundation that was available to them. By the time Mr. Kohberger was on their radar as it relates to November 13. And I'm not seeing that as the problem.
My first question to Special Agent Balance, who would be the person who would have gotten these through a different channel through the FBI, would have been, did you get them? Because I've heard different things along the case, asking him the question is really what I wanted to be able to do. And that's why I opposed this motion and prepared it as I did.
Tell you what, I'll let you ask that question outside the presence of the jury.
Thank you.
At the time of trial.
And that is what he ruled. The judge ruled that Ann Taylor can ask Agent Balance that question outside the presence of the jury. If he says yes, then, she can go forward with what he's characterizing as a conspiracy theory. If the agent answers no, then that's the end of it, period.
That will satisfy me. Thank you.
I'm not upset, but I just for Mr. Ray's information, because he wasn't here the first day I started.
So people are saying that this comment that this judge is making now is directed at the prosecution because she happened to be up at the podium. Oh, no, it's not. This is him. Let me just back up a couple seconds. This is him. He's still directing. He's still
supposed to
talking to
that
Ann
time,
Taylor.
For all I know, he didn't name names. He didn't identify it. He didn't put it into any context. The state had indicated and they provided AT&T sworn testimony that they only keep them for 7 days. And yet he makes the accusations that he did in his affidavit without addressing that 7-day issue at all. And so I guess my point is if you want to cross-examine the witnesses about why didn't they rely on the AT&T timing information, you've got to show some factual foundation that was available to them. By the time Mr. Kohberger was on their radar as it relates to November 13. And I'm not seeing that as the problem.
My first question to Special Agent Balance, who would be the person who would have gotten these through a different channel through the FBI, would have been, did you get them? Because I've heard different things along the case, asking him the question is really what I wanted to be able to do. And that's why I opposed this motion and prepared it as I did.
Tell you what, I'll let you ask that question outside the presence of the jury.
Thank you.
At the time of trial.
That will satisfy me. Thank you.
Okay, so then Ashley Jennings comes up and the judge is still upset. He looks mad.
And I'm not upset, but I just for Mr. Ray's information, because he wasn't here the first day I started this trial with you folks. I said, I don't want theatrics. I don't want accusations that aren't supported with evidence about supposed bad conduct of the parties. You're all professionals. I respect you all. And the accusations he made in there are very concerning.
So he's not talking to Ashley Jennings. She happens to be at the podium, but he is still talking to Ann Taylor.
The kinds of accusations, if true, that would get people disbarred. And so without any evidence and apparently sidestepping the clear explanation, he makes those. And so that doesn't make me happy.
So that is addressed, even though Ashley's at the podium, that whole thing is still being addressed to Ann Taylor and the defense team. I just wanted to play it in its context because this has been hotly debated in the comment section. So let's see where we are with our poll. Hey, Amelia's here. Amelia's our other head mod. Let me see if I can find you the poll. I might have let this go too long. Okay, here we are. I found it. Thank you for giving me a minute. Okay. So if he has autism, put a 1 in the chat. If he doesn't, if you don't believe he has autism, put a 2 in the chat. Lucy says 1. Bab says 2. Shadow says 1. Hi, free to be me. Val says 2. Lori says 2. Gypsy says 2. Wait, what says 2? Christy says 2. Urban says 2. Red Cloud says 2. Beverly says 2. And Jess says 1. Free to be me says 2. Hey, DM. Thanks for modding today. Ashley says 2. Pinjam says 2. So I asked, does BK have autism? Yes. Put a 1 in the chat. Oh, so no is a 2. Sorry, my bad. Yes, he has autism is a 1. No, he does not have autism is a 2. 2. So no, he does not have autism is a 2. Yes, he does have autism is a 1. 2. David says 2. Edward says 2. Sharon says 1. Let me see. DM says 2. Hey, ASP Lizzie. Definitely on the spectrum, in my opinion. Barb says 1. Sadie says 2. Regina says 2. Dion says 2. Simpson says 2. Marilyn says he may be on the spectrum, but it shouldn't matter. Can I cook it? Says she doesn't want that question outside her expert. Otherwise, she would be allowed prosecution to have a secondary diagnosis. Afro says, I think it's convenient. Thank you. Hi, Cami. Shadow says, I don't know what that is. Sorry. Ashley says, being on the spectrum myself, them trying to use autism spectrum disorder as a crutch or an excuse for his actions is sickening. Thank you for sharing that. Barbara's changing her 1 to a 2. Linda says 1. Lizzie said it definitely shouldn't matter. Brother Mike says 2. Shadow thinks he's totally on the spectrum. Kirsten said he isn't. I have over 33 years experience. Brian isn't autistic. He is mentally disturbed. Donna says 2. Tammy says 2. All right. So we have a mixed bag there. Have another 2. Leslie says 2. Free to be me says, I'm on the spectrum. Doesn't affect knowing right from wrong. All right. So, very, very interesting. We got kind of a mixed bag on that one. And then thank you, Kami. She says, I want to be sure to donate. I will be in and out for some time as I'm super sick with liver issues. Love my reporter room family. Kami, I'm so sorry that you're out sick. I hope you feel better. I really do. I'm so sorry to hear this. Amelia, thank you so much for gifting a reporter room membership. Oh, and gifting another reporter room membership. So Enjaz and Amelia have both gifted 2 reporter room memberships each. That's so nice of you guys. And thank you to Kami and Brother Mike for your super stickers. All right, so let's continue on. We still have a lot to unpack. I just wanted to go through that because that has been hotly debated in the comment section, where people have said because Ashley Jennings was standing up there that the judge was upset with her. And I, just wanted to play it in its full context so you guys could see that the judge is pushing back on Cy Ray, and he characterized what Cy Ray was claiming as a conspiracy theory. So let's go through the 4 most important things that could sway the jury, and then we're going to talk about a clue. So let me grab this. Let's take this down. And let me grab this. Ooh. They have a new present and invite button, so I keep going for the old one. Okay, so my sourcing on this is Fox News. All right, 5 things that could sway. So, number 1, will BK testify? In any trial, calling the defendant to testify is a risk. On one hand, it's impactful for the jury to hear the defendant claim innocence with information that can support that claim. However, it sets up a cross-examination from the prosecution, which can rattle a defendant in what's already a highly charged situation. We saw Alex Murdaugh take the stand in his own defense, and he was a seasoned trial attorney, and the prosecution ate him for lunch, in my opinion. Evoking anger or frustration will help the prosecution. Prosecutors paint a picture of the possibility that BK could have performed such a heinous act. The prosecution, in this case, wants to use BK's testimony to disprove his alibi, though the defense is looking for other ways to corroborate it. So the judge has given the defense more time to corroborate his alibi. And then if he doesn't have corroboration, then the only way he will be allowed to is to actually take the stand. What is the defense? Number 2, no motive has been established, and Kohberger's defense team wants to make the argument that someone else could have planted the knife sheath with his DNA at the crime scene. If Kohberger's defense team plans to argue the possibility of another attacker or multiple attackers, a jury is going to want evidence that points to a specific person or persons. And so the judge has said, if you're going to offer an alternative suspect, he's told this to Ann Taylor and the defense team, then you need to tell me who that is and what evidence you have that they are involved in this. So she can't just pick somebody out of thin air. So even if the possibility of an anonymous attacker is on the table, there needs to be support through DNA evidence or some type of surveillance footage that captured someone other than Bryan Kohberger at or near the crime scene at the time of the crimes. So she can't just pick somebody out of thin air. She needs to support it through some type of surveillance video or DNA evidence that captures somebody else besides Bryan Kohberger at or near the crime scene. So that really is going to limit who she's going to be able to select from. And in my opinion, she's down to the DoorDash driver or one of the 2 roommates. That's really the only people that she's going to, in my opinion, have to select from, unless there's some information out there that we don't know yet. Number 3, key evidence in the case. As early as April, the defense prosecutor for the case, Ashley Jennings, filed the evidence list with the Idaho trial judge who will be presiding. This includes records from a Pittsburgh, Pennsylvania Dick's Sporting Goods, where the prosecution claims relevance for BK's purchase of a back balaclava in January of 2022. So far we know about the balaclava in January of 2022. We know about the K-bar knife, the K-bar knife sheath. And I just wanted to say one clue that I think that we all missed is that, and then some of you guys brought this to my attention one of you guys brought this to my attention in the comment section, which is that BK and his veganism. I've had people say, he couldn't have done anything to Buddy. He couldn't have done anything to the 4 roommates because he was a vegan. But this is one clue that we all missed. That knife sheath is leather. It's leather. So if he was really a pure vegan, then he wouldn't have picked out a leather knife sheath. And you will recall that he purchased a knife sheath, and a knife sharpener in March of 2022. So not a pure vegan, and that is an important clue, in my opinion. The type of mask that was described by the student who also lived in the house, so that's going to be Dylan, witnessed the killer fleeing through the back door. Now, I think that is going to be Bethany. Prosecutors also want to introduce video footage at the Sunset Mart in Moscow, Idaho. And we talked about that at the very beginning. If you didn't see that, the mystery traffic stop and how that's going to help the prosecution's case, you'll want to back this up and watch that. I addressed it right out of the gate. It allegedly captures BK driving to and from the crime scene, to and from the 1122 King Road home, not on the night of the crimes, but it's going to line up with those cell phone tower pings. The evidence is meant to support a timeline of BK's activity leading up to and after the crimes took place and fill in any gaps that dismantle the argument that another attacker was involved. Number 4, jury selection. Because the case is so highly publicized, it's going to be challenging to find an impartial jury, which is why Judge John Judge agreed to Ann Taylor's motion to move the trial from Latah County to Ada County. She also has the benefit of having a more liberal jury in Ada County, even though Idaho is a red state, because it's a bigger city. So a change of venue was already court ordered by the Idaho Supreme Court, moving the trial to Ada County rather than Latah County, where the crimes took place. Number 5, witnesses expected to take the stand. So it's going to be really interesting to see who the state calls as its first witness, since it's usually the strongest witness to set the narrative. And I'm curious of who you think it's going to be, because here are some of the choices. Expected witnesses, and I don't think that the roommates are going to be the most important witness. I think it's going to help to bolster the case of the bushy eyebrows, but I don't think it's going to be as important as like the DNA evidence, the phone pings, the CCTV camera of the Hyundai Elantra, that traffic stop on August 21st of 2022 that we don't know about, but I shared a bunch of information on that. So expected witnesses to be called to pick from include various law enforcement agencies and forensic experts. The prosecution's list includes Detective Lawrence Mowry. He was an investigator on the case. The Latah County Coroner, Kathy Mobbitt, and the Spokane County Chief Medical Examiner, Dr. Veena Sai. Maybe it's pronounced Singh. I'm not sure how she pronounced that. Another potential experts are to be called are FBI agents Tony Immel and Nick Balance. Nick Balance is prepared to speak about the location of Bryan Kohberger's cell phone before and after the students were done away with. I'm watching my words here. Another expert the prosecution may call is Shane Cox. As a manager with Amazon's law enforcement response team, Shane Cox is responsible for subpoena responses and search warrant requests. This testimony may not provide the full context of the workings of Amazon or BK's account. And remember, we now know that not only did he purchase the knife sheath, but he had it delivered to the Albrightsville, Pennsylvania, that the package was addressed to him, Bryan Kohberger, and he looked up the tracking to see when the package was going to arrive. So I think the prosecution will also show receipts proving that he paid for it. However, the prosecutors argue that the purchase of the K-bar knife and sheath allegedly used to do away the 4 students make it relevant. And, the judge did agree that is coming in. And then BK deleted his Amazon search history after the students were done away with, after November 13th of 2022. He deleted all his search history and then was looking around for another knife. And the jury's going to want to know, where's your knife? Where's your knife sheath? Where's your, because it wasn't listed in any of the evidence that was collected by law enforcement. So Boise-based expert Dr. Gary Dawson is also expected to be called to the stand by the prosecution to rebut the defense's claim that there were multiple attackers. His testimony is expected to include information about the victims' intoxication levels, which would render them unable to fight back against a single assailant. And if you think about a 7-inch blade, that would go all the way through somebody's neck, in my opinion. So both sides have submitted their legal expert list. They have until later this month to disclose non-expert witnesses to testify to their personal experience. And this may include the surviving roommates, Dylan and Bethany, which the judge has ruled they can both testify. Also, the state claims it may call Bryan Kohberger's family members. They have said, according to the defense team, they have no interest in helping. But as the trial date nears, more evidence, experts, and potential documents are going to be filed. The trial starts August 11th of 2025, and we have jury selection beginning July 30th of 2025. So let me add this back in. All right. So a lot of really good information, I think, on this today. Hopefully you understand better why the traffic stop is so crucial. Let me see where we are in chat. I do, let me take this banner down for a second. I do want to say thank you. We're not done, but I just don't want this whole live stream to go. And I didn't say thank you to our producers and Jazz, Sasha Angel, George Brown, Pepper, and Christy Valentine. And thank you to our channel members. Thank you so much for your support and allowing me to be able to cover cases like this. After this, I'm going to be doing the Chris Watts case. I was planning to do Sebastian Rogers, but there isn't a lot of new information related to Sebastian Rogers, and there is some new information in the Chris Watts case. So I'm going to be doing that case right after this. If you want to follow me over to that live stream, it's going to be really, really interesting. We're going to be talking a lot about Nicole Kessinger. Should she have been held more responsible than she was? Did she, get away with something here? And I also want to give super thanks, gratitude to Mike and Kami and Shelly and Shannon, gifted channel memberships to NJAZ, and Roxanne, Jeannie from the Seattle area, and Brother Mike. Thank you so much for your super thanks, and thank you, NJAZ, for your gifted channel membership. And then today we had gifted channel memberships from Amelia. So let me write that down too. I just want to make a note of it. Because if I don't, I'm worried I'll forget. If you are a channel member and I don't have your name listed, please let me know. All right, let's take a couple of questions. I saw Mike in here today too. Let's see. Deeb says, Jessica, I think they might have him on camera signing for his order upon delivery. You're talking about Amazon? I don't know. Wow, that would be something. Let me move myself over here so I'm not blocking myself. Bree says, I don't see it happening. He would get roasted. Hey, Sirius. Mike says, that knife is huge. So sad for them. I can't imagine. Yeah, when you think about a 7-inch blade, it's like this. Let me see if I can get myself on camera. It's like this, it's pretty big. So if you think about like that going through your neck, it would go all the way through. It would go all the way through and it would be sticking. If somebody came at me from the back, it would be all the way through and sticking out the front. If it came at me from the front, it would go all the way through. So you could see where you could silence somebody. And I don't think these crimes sounded like what we think they sounded like. I know a lot of people have, criticized the roommates who were drunk that night for not calling law enforcement sooner. But, I feel like let's hear what they have to say. And I just don't think the crime sounded like what we think, because Ethan and Xana didn't call 911 either. So Ms. Holly says Xana's sister was attending WSU. I wonder if that's how BK first encountered the girls. Maybe they went to a WSU party. I don't know. Thank you for modding today, NJAZ. Jennifer says, I feel like people siding with the defense forget that BK could simply answer a couple of questions from his attorneys and explain away a big part of their evidence if he were innocent. Yeah, I think he could definitely take the stand. It would be, but it is his right not to take the stand. I don't think Ann Taylor is going to put him on the stand. Let me know if you have a different opinion. Holly says she hopes he does testify and explain his alibi. Hey, Regina. Barbara says a lot of evidence points toward Bryan and a lot more we don't know about yet. Yeah, we don't have everything. We still haven't found out about the ID that was inside a glove inside a box that's supposed to be related back to the 1122 King Road house. We still haven't found out who the animal hairs belong to. Is it Buddy the dog who belonged to the Colberts? Or was it Murphy the dog who was Kaylee and Gonzalez and Jack DeCour's doodle? So Labradoodle. AZ said, I just need a replacement weapon. Yeah, right. Siri says, I'm glad you got, oh, whoops. Susan said, the big clue, in my opinion, is realizing that the sheath is leather. Vegans don't use animal hide. I dated a vegan who had leather seats in his new caddy ripped out for cloth. So that is a real vegan. Wow. Yeah. So I think that was like a big clue that we all missed, was that and you guys, one of you guys caught it in the comment section. That's why I love reading your comments. But the big clue that we all missed is that knife sheath is leather. And if he were purely a vegan who would never do anything to people and never do anything to animals, then why does he have a leather knife sheath? Why did he choose that? Because he specifically selected that. Me, myself, and I said, did he search a new knife and sheath before it was public that they found the sheath at the scene? Well, I think he knew, just from looking at Pappa Rogers' posts, I think he knew he left it. But that's just my opinion. We'll find out more at the trial. Can I Kick It said, I think BK has to testify if he wants any chance of being free. There is too much evidence. And Dion said, yeah, and he looked for a replacement. Yeah, he did. Let's see where I'm at with comments. Justice for Kaylee, Maddie, Xana, and Ethan, says In Jazz. Yeah, Susan said that knife size, it's awful. Yeah, it's huge. I mean, people are like, well, why didn't the roommates had to hear something? I don't think so. I think with this, with a 7-inch blade, when you're thinking about trying to get my hands on camera, if you're thinking about like a 7-inch blade, how long that is, and then you think about, like my whole torso, it could go all the way through me and stick out the other side. That's how big it is. DM says, I remember the UPS got a subpoena. I wonder if it's relevant to I think it could be relevant. Yeah, could be. And Jennifer says his veganism was an attempt to combat his visual stow symptoms. It has nothing to do with caring about actual animals. Mike said, yep, it's just ruckus. And AZ said, that knife is a K machine, to put it bluntly. Yeah, it is. Bushit said, your voice is so similar to the DA in the Arizona versus ballot trial. Mine? Oh, wow. Jewel said, allegedly, Maddie went to Washington University for a week before going to Idaho. I've heard that too. I haven't been able to confirm it, but I have heard it. Mike said, DM, they want ups in the video, I think I recall. And Sierra says, please take a minute and hit the button and subscribe. Yeah, please subscribe. Help a girl out. Subscribe. It's free. It helps me a lot. If you want to be a channel member, that helps me out even just a little bit more. And if you just want to consider sharing this video with your family and friends to explain, what the judge said, because this was so hotly contested in the comment section. People were arguing about it, about who the judge was directed to. And I think there was some honest confusion because Ashley Jennings was standing at the podium. However, if you watch it and if you just showed that clip and you didn't see the context of the whole conversation that led up to that, you might think he was directing that at Ashley Jennings. But you can see her body language as she's open and she's looking back. Her body language is open toward the defense. She knows, even Ashley knows who he's directing his comment to. So Jennifer says, I believe the size and shape of the knife are possibly what DM confused for a vacuum. Yeah, it could be, or it could have been some type of ill kit, with a K. Bree says it would be hard for him to do anything, especially with them not having anywhere to run. Yeah, I mean, I think there's going to be some people, Micro, that no matter what evidence is shown, they're not going to believe it. And that's okay. I'm not here. This is a critical thinkers channel, so I'm not here to tell somebody else what to think or not to think. I think that everybody has the right to make up their own mind, and I respect everybody's opinion. So it's okay if we don't all share the same opinion. We're not going to all agree on every case. And with that said, I am going over right now to do a live stream on the Chris Watts case. If you would like to follow me over, we're going to have a really good live stream on that. So please subscribe, and I will and be on the lookout for another Bryan Kohberger video in the next couple of days, because we still have more important information to go through and unpack leading up to jury selection, which begins July 30th of this summer. Thank you so much for coming by to spend a little bit of time with me, and I will see you on the next one.